The last one.
That's the last one.
Before we even hear a single word from the bench, let's set the stage. Because this case is not just about custody, it's about authority, defiance, and what happens when court orders are treated like suggestions instead of law. We're in Michigan, and what unfolds here is a slow-burning legal disaster that starts with a divorce, escalates through CPS involvement, and ends with a criminal bindover for custodial interference. At the center of this storm are two parents with a fragile, court-ordered parenting schedule, and a moment where one of them decides, I don't believe this order applies to me. That decision alone is going to cost dearly. We'll see how law enforcement gets involved, how confusion over dates and orders becomes a defense strategy, and how Judge Simpson methodically dismantles the argument that disbelief excuses noncompliance. Pay close attention to the timeline. Every day matters here, every order matters. And most importantly, what you do after you receive a court order matters more than what you believe about it. Question for you already. If a police officer hands you a court order you don't believe is real, do you comply first or refuse and check later?
Okay, here we go.
See that? Very official. Self-authenticated. Is that? I'm not sure.
Ready? Court does call the case of the people of the state of Michigan versus Lovely.
I think you would, good afternoon, Jonathan Memons on behalf of the people.
And Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lovely, who stands to my right in court.
Okay, thank you. We're ready to proceed to exam.
Defense is ready.
People are ready to proceed in this matter. My understanding is that there's also some kind of a violation hearing. Did you want to do the exam and then kind of do everything all at once, or however?
Yes.
You want to proceed? Perfect.
That's
Not that there's anybody else left. I'm going to call my first witness, is going to be Corey Johnson, but I have the officer in charge, Dusty Patel, also here with us today.
all right. Sir, please come forward. Be sworn.
This moment marks the formal beginning of testimony, and it's important to understand what the court is doing here. The witness, Mr. Johnson, isn't just recounting a family dispute. He's laying the legal foundation for criminal charges. Every question that follows is designed to establish three things: a valid custody order, notice of that order, and intentional non-compliance. Notice how carefully the prosecutor handles the presence of a child. Names are deliberately avoided, not for drama, but because family court cases demand strict privacy protections. This immediately signals that the court is taking this matter seriously and professionally, not emotionally. From a legal standpoint, this testimony is about credibility and chronology. When was the divorce finalized? When was the custody order entered? Who had the child and when? These aren't background questions. They are the bricks used to build probable cause. And here's something viewers often miss. This isn't about who is the better parent. Criminal custodial interference cases don't require bad parenting, only disobedience to a lawful court order.
Comments for our firm testimony you're about to give? The truth, the truth, and nothing but the truth. Statements represent the record.
George, I think. All right, go. You may inquire.
Yeah, thank you. And good morning, Mr. John, or good afternoon, Mr. Johnson. Thank you for being here today. Just to kind of get right into it. With the court's permission, there's a child involved here. I'm just gonna refer to it as the child so that I'm not putting his name.
That is fine.
And likewise, if defense could. Do you have a son?
Yes, I do.
Okay, and who is the mother of that child?
Defendant.
Okay, and just identify her. Okay, and is that somebody who you see here in the courtroom today? And how do you know Miss Lovely?
She's an white.
Okay, and you guys are obviously divorced then?
Yeah.
When was that divorce, when did that become effective?
2019.
Okay. And as such, out of that divorce proceeding, was there a custody arrangement that was entered into regarding your child?
Now we're officially inside the custody framework, and this is where things start to tighten. The witness explains the parenting schedule: week on, week off, school exchanges, Friday transitions. It sounds routine, and that's exactly why it matters. Courts love routine. Predictability equals enforceability. Once a schedule is established, any deviation requires court permission, not parental improvisation. When Mr. Johnson testifies that the arrangement changed due to CPS involvement and then CPS cleared him, that clearance becomes a critical turning point. This is the moment where the defense's future arguments begin to weaken. CPS stepping out means the original order snaps back into effect unless a judge says otherwise. No gray area, no pause button. What follows is subtle but devastating. Johnson testifies that CPS explicitly told them to resume normal custody, and that didn't happen. That single failure triggers police involvement, emergency orders, and eventually criminal charges. Key legal insight: CPS investigations do not override court custody orders indefinitely. Once CPS clears a parent, the court order regains full force.
In September of 2022?
Yes.
Can you briefly tell us what the terms of that arrangement were?
Yes, we each had 50-50 custody, joint custody. And then we did our exchanges on Fridays.
Okay. And so is that one parent would drop them off at school, the other parent would then pick them up?
Yes, you complete your week by dropping them off on Friday, and then the other parent would start their week picking them up.
Okay. So I want to fast forward to Thursday of February of 2023. Did anything change regarding that arrangement, that custody arrangement?
Yes, that the first week of February, I would have had custody of my son. And I was contacted by investigating the claims that she had made against me. They turned out to be false. So I believe it was like the 6th, they had contacted me and they said, we're gonna go back to normal custody. We advised her to continue like you should be, dropping him off at school, and I would pick him up, et cetera. And that never happened.
Okay.
He was never returned.
So February 6th of 2023, I believe that was a Monday.
A Monday or Tuesday.
Okay. You were supposed to have the child on what day? That Friday. So roughly the 3rd. I looked at a calendar earlier.
Yeah, I'd have to look at it.
Okay.
Well, hold on. I just want to make sure. On the 3rd would have been your pickup, the beginning of your custody.
Yes.
Okay, go ahead.
And then that should have terminated with you dropping the child off on the 10th.
Yeah, Friday.
Okay.
Whatever the Fridays were. Got it.
All right. And so then now turning to the 6th of February, CPS gives you the okay to resume your pickup. Do you have any interaction with the defendant regarding the child exchange on the 6th?
Yeah, she contacted me on our family wizard.
Okay.
Told me she was not returning.
Okay. Prior to February 6th, had you been observing her social media feeds?
Yes.
Okay. And did you have any concerns about what the defendant was going to do with herself and the child?
Objection, Your Honor, as to the relevance of what's on her, allegedly on her social media feed, certainly with regard to what he may have speculated he was worried about her doing.
Well, but that goes to his state of mind as to everything. I'll overrule the objection. I'll hear it.
This ruling is a quiet but powerful moment. Defense tries to block testimony about social media, and Judge Simpson immediately recognizes why it matters. State of mind. In criminal law, intent is everything. Whether the defendant believed she had the right to withhold the child becomes relevant, not because it excuses her actions, but because it explains them. Social media posts suggesting travel plans or instability can show foreknowledge preparation, or disregard for custody obligations. Judge Simpson doesn't say the posts prove guilt. He says they help explain why the father was alarmed. That distinction is crucial. Evidence doesn't need to prove the crime outright. It only needs to make the narrative more complete. And this ruling also foreshadows what's coming later. The court's increasing frustration with a pattern of ignoring orders, rules, and restrictions. Legal takeaway: evidence isn't excluded just because it's uncomfortable. If it explains motive or intent, it's often admissible. Audience question: should social media activity play a role in custody-related criminal cases? Or does that open the door to unfair scrutiny?
Go ahead. Yeah, so had you been kind of monitoring her social media?
Yeah, I was concerned that she was going to take state.
Okay. With a specific destination?
New York, that's all I knew.
Okay. And so did you share those concerns that you had with the defendant at all?
Yeah, I told her that would be a violation. We were required to provide an itinerary to front of work, and that never happened.
Okay.
I verified that with Sarah Mazer. She said they hadn't received an itinerary, and that what she provided wasn't appropriate.
Okay. So on the 6th, obviously the child does not return to your care.
Right.
Okay. What happens then on the 7th?
I contacted and law enforcement in reference to the issue. A order was filled out and sent to the judge by a friend of court to pick my son up and return him to me. That was signed by Judge O'Brien.
Okay. Did you anticipate that you were going to be able to pick up your child from school that day?
Yeah,
Okay. Did you reach out to the school at all?
I did, and they told me that he hadn't been brought that day.
Okay.
I think he said it was like mental health or something like that.
You obviously didn't excuse him. Okay. Okay. All right. The order, when you contacted the friend of the court, were you able to receive a copy of the order from friend of the court?
I did.
Okay. I'm going to approach with what's been marked as people's proposed exhibit number 1.
If I may, Your Honor.
Yes, you may.
All right, Mr. Johnson, that exhibit that I've handed you, you've had an opportunity to review that before testifying today?
Yes.
And is that something that you're familiar with?
Yes, this is the order that they sent to the judge. That she's
Okay.
trying to pick up.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien at the 22nd Circuit Court?
Yeah.
Okay.
Got it.
And that's the order. What was that order informing what was supposed to happen with the child?
I believe, let me read it just to clarify. Says that she's supposed to return to me immediately and not leave the state of Michigan.
Okay. Your Honor, unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 1.
No objection for purposes of exam.
Exhibit 1 is admitted.
Did the court want to review that?
Yeah, I'll say.
Thank you.
Thank you. Standard order. Okay. Go
Thank
ahead.
you. So now turning your attention then, so that February 7th, that order gets signed. You said that you contacted police. What agency did you contact?
I contacted Northfield Township, and I believe it was a detective that called me back. He called me back.
Okay.
I sent him that document that I had by email, and then he basically said because of the multi-jurisdictional thing that he was going to forward it to the state police.
Okay. And as such, did you end up later that day speaking to Trooper Pitzel? Pitzel. It rolls off the tongue. Pitzel. Okay. All right. And where did you speak to him at? Where did he come to your house? Okay. You spoke to him over the phone. Did he? Well, you kind of explained the situation to him as best you could. Okay. All right. Moving forward to Friday the 10th.
Days pass, and nothing changes. This silence is legally loud. Each unanswered day strengthens the prosecution's case that this wasn't confusion. It was refusal. Johnson testifies that by February 10th, he still does not have custody. By the 13th, still nothing. The court now sees a pattern, not an accident. Patterns are dangerous in criminal law because they suggest intention. And notice what the judge later clarifies. The original order may have restored the normal schedule, but the second order on the 14th removed ambiguity altogether. From that point forward, custody was crystal clear. This matters because even if the defense argues confusion early on, that argument collapses once a second. Unmistakable order is issued. Legal insight. Confusion might explain delay, but it does not justify continued noncompliance after clarification. Audience check. At what point does confusion stop being believable and start becoming defiance?
Had you received custody of your child by the 10th?
No.
Okay. Then moving forward to the 13th, that Monday, February 13th, by that point in time, had you received custody of your child? Okay. And it's your understanding that pursuant to the order, the child was supposed to remain in your care until further order of the court. Okay. All right. So then tell me what happens on the 14th of February. Had you, on the 14th of February, so this is Tuesday, had you received custody of your child? Okay. So what did you do, or what happened in terms of that custody arrangement?
And contacted front court and law enforcement and advised them that at that point she wasn't even in Michigan anymore. I
Objection, Your Honor, foundation as to where she was.
I can, if it,
Well, he is, as I understand his statement, whether it's true or not, that's what he's indicating. So there may not be foundation for what it is, and the court will give it whatever weight I give that statement, but I'm going to overrule the objection. Go ahead.
thank you. Go ahead. So I'm sorry, you reached out to friend of the court. You gave them some information.
Yes,
What happened as a result of that information?
they submitted another order to the judge. And this was for her, this was terminating her parental rights, and she had until the 24th. It's an ultimatum.
The word ultimatum isn't used lightly in court, and here it's earned. The February 14th order strips away flexibility and replaces it with finality. Return the child immediately or face consequences. This is no longer about parenting time rotations. This is about court authority. And the judge makes clear later that once this order is issued, any further withholding is not a misunderstanding. It's a violation. From a legal standpoint, this order resets the entire analysis. It gives the prosecution a clean starting line for criminal liability. Key takeaway: courts escalate when earlier orders are ignored. Each escalation increases potential penalties. Viewer question: should courts move faster to criminal enforcement in custody disputes, or is escalation already too aggressive?
That she had to return them to front court by then. That was the latest, but it was to immediately do that.
The 24th of February.
Yes, sir.
Thank you. And if I may approach with people's proposed exhibit number 2, the 14th.
Yes, you may.
Thank you. Mr. Johnson, you've been handed what's been marked as people's proposed exhibit number 2. We just talked about the court order, the document in front of you. Do you recognize that item?
Yes.
Likewise, did you have an opportunity to view that before testifying in court today? I have. Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien on the 14th of February of this year?
Yes, it was.
Okay. And unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 2.
No objection for exam purposes, Judge.
Exhibit 2 is admitted.
All right. So then this order gets signed.
Communication, or lack of it, becomes the next focal point. Johnson confirms ongoing contact with law enforcement, but no cooperation from the defendant. Silence in this context isn't neutral, it's damning. When he testifies that she never responded meaningfully, it reinforces the narrative that she wasn't seeking clarification. She was stalling. This matters because courts expect proactive behavior when orders are unclear, calling the clerk, filing a motion, asking for emergency review. None of that happens here. Legal principle: good faith confusion looks active. Bad faith confusion looks passive. Engagement question. If you were truly unsure about an order, what steps would you expect someone to take?
Without telling me what you spoke to, had you been communicating back and forth with the trooper during this period of time? Okay.
He advised to contact
Well, don't tell me what he told you. I just want to know if there was still that communication. Okay.
keep me updated on the status of the.
And had you been communicating with the defendant at all, sending either via Family Wizard or otherwise?
No, I sent her a message stating that I was contacting the authorities. She didn't return my child.
Did she ever respond in any kind of way? Okay. All right. So then to finish this up, when was the next time you actually received custody of your child?
I called the school Wednesday or Thursday. It was like 16th, I think, that week when they said he was there, that he'd been dropped off. And so I told them that I would be there early, pick him up. And I had the order. I gave them a copy of that. And so they were aware that I had custody of him.
Okay. All right. And that was February, you believe, 16th of 2003, Thursday. Okay. And again, at that point in time, to the best of your knowledge, between February, well, I guess 6th and February 24th, so this is after communicating with CPS, to I'm sorry, February 16th. It was the defendant that was the only barrier between you and having custody of your child? Okay. There was no communication that he was missing or anything to that extent. And in fact, had you spoken to your son during that intervening period of time?
Not allowed to have a phone call with him, just the one.
Okay. You had one phone conversation with him? You recognized his voice? Okay. All right. And I guess, how old is your child? Okay. So he doesn't, he may, I guess, but does he have a phone? Okay. So when you spoke to him,
Yes.
how did you get in contact with him?
We are required to call each other's cell phone.
Okay.
So I call her Alante cell phone.
Okay. And so you called the defendant's cell phone and you were able to speak to his son.
Yeah.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this witness.
All right. Before you begin cross-examination, I just want to clarify one thing.
Judge Simpson steps in here not to help either side, but to clarify the record. This is judicial precision at work. He parses dates, sequences, and intent, because juries live or die on clarity. This moment exposes a key defense vulnerability. Misunderstanding does not erase obligation. The judge distinguishes between returning the child and remaining in custody, making it clear that either interpretation still required compliance. And when he says, "That didn't happen," the implication is unmistakable. Judicial insight. Judges are not confused by complexity. They are irritated by excuses. Viewer question. Do you think the defense confusion argument holds any weight after this clarification?
The first order, sir, that was signed on by Judge O'Brien on the 7th, there was an indication that the child was to be returned to you, that your understanding was that the child was supposed to be returned and remain in your custody.
Yeah.
As I'm reading this,
Go back to 50/50, our regular agreement.
okay,
I think
that's fair. And if I'm counting out the dates, had the child would not have been returned to you really until the 14th, right? If I've got it.
week. I was supposed to have him that first week, but the 3rd.
Correct. So you would have the third basically through the 9th.
Yeah.
Right? Then the defendant would have the 10th through the 13th. And then your next time would have been the 14th and beyond,
The 17th.
or the 7th.
Yeah, whatever that Friday would have been.
Yes, the 17th and beyond, I guess.
Yeah.
So I guess, okay, so here's what I'm trying to figure out. I'm looking at this order and I'll let you see it again, the order of February 7th. And it indicates that they're ordered to immediately return the minor child to defendant's father custody care and so on. Had that order been effectuated on the 7th, you would have then had the child from the 7th to what, the 10th?
Yeah.
Okay. And that's what didn't happen. Okay.
I didn't get him on the 3rd. I didn't have him, he was never returned. I never got him that week at all.
Right.
Yeah.
So, but what I'm saying is the time, I don't know really what I'm saying. What I'm indicating is you didn't get the child on the 3rd. The order to return the child to you signed the 7th. But if everything were to go back, really, there's like 3 days from the time of the order that it didn't happen. I mean, from the time of these orders, right? 3 or 4 days. Okay. The week then of, oh, let me just stop there for a moment. Because one of the questions the prosecutor asked you then is, on that order, that the child was to remain in your custody. That's not quite correct. On the 7th, is that right?
I believe she's supposed to be returned to me so we can continue our parenting time.
Okay, so, okay, that's something different. That's what I'm trying to figure out. On the 7th, the judge is ordering that the child be returned to you as though this interruption had not occurred. And then it would go back to the normal schedule, right? So from the 10th to the 17th, the defendant would have had primary possession of the child at that point, not really custody, but possession.
Yeah.
What interrupts that, though, is then the order of the 14th, which then says, and this may have, I just want to be clear on it because it may be what you were talking about, the 14th order. That order doesn't, as I'm reading it, isn't now referencing the parenting time. That order is saying this child goes to the father. That's it until the court says otherwise. Is that your understanding?
Yes.
Okay. That, pardon?
That's how friend the court explained it to me as well.
I probably did a better job though, right?
You did.
Okay, thank you. All right, thank you. No, it's okay.
This light moment, a brief joke, actually serves a purpose. It shows the judge is comfortable, confident, and fully engaged. Humor here isn't casual. It signals command of the facts. When judges joke, it usually means they've already made mental determinations about credibility. Subtext: the court understands the timeline and isn't persuaded by spin.
All right. Cross-examination.
Judge, if I could just have a moment.
Yeah.
May I receive the exhibits?
Mr. Johnson, are you currently employed?
Yes.
How?
I work at Diablo Salsa.
You do what?
I work at Little Diablo Salsa in the morning.
Little Diablo Salsa. Were you previously employed as in law enforcement? When were you employed in law enforcement?
In 19.
How long were you in law enforcement prior to that?
Your Honor, I guess I'm gonna object to the relevance of the question.
What is the relevance?
Judge, if I'm allowed to understand his involvement with law enforcement, it might explain why he chose to involve law enforcement in this in order to deal with what is a civil matter.
I don't know. I'll let you go. I don't think it's gonna matter to the court because if a child's withheld against a court order, I don't know that that's a civil matter, but I'll let you have your definition. Go for it.
How long, when did you start working in law enforcement? And where did you work?
Police department. I work for Amber Township, Northfield Township, and shortly, a little short stay at like the Golden Stockbridge. I did reserve work.
Prior to the reserve work, you, Northfield, Hamburg, and Pinckney, you were working there as a police officer? Would you describe this, the child custody arrangement in the course of your divorce as contentious?
Somewhat, yeah.
And this all started when Ms. Lovely filed a Child Protective Services complaint against you, correct?
And what else?
This particular incident.
Yes,
When did that happen?
I believe it was beginning of February. Amanda Moore contacted me from CPS in Oakland County.
So early February, CPS contacted.
This is the turning point. The trooper doesn't speculate. He reports words. She would not return the child. Not confusion, not delay. Refusal. From here on, everything else is justification, not defense. Legal truth, refusal after notice equals probable cause.
You indicated that an investigation was being started. And you were told that it was based on allegations made by Ms. Lovely.
Yes.
And you said, you testified that investigation was closed.
Yes.
When did that happen?
We got the 6th.
And how were you made aware of that?
I spoke to Amanda Moore, the investigator.
On February 6th or February 7th, you said you contacted a friend of the court.
Yeah.
Did you also file an ex parte motion and that motion was denied, correct?
Yes, because they authorized the other one, that front of court.
But you filed a motion and that motion was denied.
Yes.
Okay.
An ex parte motion. What?
That was an ex parte motion to compel your parenting time, correct? Judge, I have no further questions.
I don't have any redirect.
All right, you may step down. Thank you. Any additional witnesses for the people?
I'm gonna call the trooper. And
Sir, please come forward to be sworn.
Yes, ma'am.
I am Trooper Dustin Peitzel. Do you want to spell it? Too?
Yes,
Okay,
okay.
that's P-I-T, Susan Charlie, yeah.
Why is that so hard, Mr. Emmons?
We just,
And I just noticed that when you called him to the stand, you
Yeah,
used the last name. You just used
I
his
asked-
title. Okay, I'm just saying,
you're on to my
I was-
ways.
I was paying attention, but go ahead. You may inquire.
Thank you. Trooper Peitzel, thank you for being here today. I want to turn your attention. How long have you been employed with the Michigan State Police?
Thank you. And were you employed in that capacity early February of 2023?
Yes.
Did you become involved in incident between a custody issue between Alante Lovelace and Corey Johnston?
Yes.
Thank you. Who did you first, or how did you first get involved in this information? And again, I would respect it to the extent that you have to refer to the child, just refer to it as the child.
At first, I was dispatched to an assistant agency. I was from my dispatch notes, I was advised to contact Detective Buxton, I believe the name was.
Thank you. And I think that's Buxton.
That's correct. Township Police Department. I contacted him and he advised me of the dispute that we're here for today.
Okay. We had some testimony earlier about their court order. As a result of that communication with the Detective Buxton, were you able to receive some kind of court order in some kind of way?
Yes, he forwarded the email to me and
Okay.
I was able to review and see the court order as well.
Okay. After speaking to the detective, based on the information that he gave you, you have a telephone conversation with Johnston?
Yes,
Okay. Did you get some line information from him?
a little bit more information on what Detective Buxton was able to provide.
Now you have the information from the Northfield Township Police as well as from Mr. Johnston. What was your next step of your investigation to assist with this situation?
My next step was to make contact with Miss Lovely and I guess attempt to persuade her to comply with the court order.
Okay, and did you do that?
Yes, I did.
Where did you speak with Miss Lovely?
I spoke with her at her residence in South Line.
Okay. And for all intents and purposes, that's I think there's a small part of South Lyon that's in Washtenaw County, but her residence is in the Oakland part.
Correct, it is in Oakland.
Okay. And is the defendant, is that somebody who you see in the courtroom today?
Yes.
Just need you to point to her and tell us what she's wearing.
It's the female with a kind of white shirt with flowers on it,
Thank you.
more kind of beige.
And for the record, Your Honor, the witness has identified the defendant.
And record shall so reflect without objection.
And thank you. Did you have a conversation with the defendant?
Yes, good.
And did you talk about the court order?
I discussed it with her. We talked through it together, yes.
Okay, and what was her response in regards to you showing her this order that she's supposed to return the child?
She advised me that she would not return the child.
This moment destroys one of the defense's strongest emotional arguments. The idea that the defendant was being reasonable by waiting for verification. The trooper doesn't say, "You don't have to comply." He says, "I'll verify it for you." Those are two very different things. Legally, the obligation to follow a court order does not pause just because verification is underway. Courts operate on the assumption that orders are valid when signed, not when personally confirmed by every party involved. The trooper offering assistance is a courtesy, not a suspension of authority. And here's the key problem for the defense. Even after verification occurs, the refusal continues. That erases any claim of good faith doubt. Once confirmation is delivered, the continued non-compliance becomes intentional, and that's exactly what criminal statutes require. This is where sympathy gives way to liability. Engagement question. If an officer says they'll double-check an order for you, do you think that gives you permission to ignore it in the meantime?
Okay. When she advised that she wasn't going to return the child, what did you do?
I told her I would be in contact with her within 24 hours. And to confirm whether she would return or not return the child.
Okay. Did you inform her of maybe some of the consequences of not returning the child?
Yes, I did. I informed her that if she failed to return the child within 24 hours, that charges would be sent up against her.
Okay. Did she, in some way, show some kind of acknowledgement that she understood what you were saying?
Yes.
Okay. So then, did you follow up with the parties at some point in time later?
Yes, on February 10th, I called Mr. Johnson again to confirm whether his son or whether the child had been And he advised me he had not been returned.
Okay, and so based on the information that you got from Mr. Johnston, did you then speak to Miss Lovely again?
Yes.
And what did Miss Lovely tell you about that?
Miss Lovely told me that she, once again, did not return the child and that she questioned the validity of the court document that I provided her.
Okay, when she questioned the validity of the court document, did you offer to do anything for her?
I did, yes.
Okay, and what was that?
I offered to, I believe that was a Friday night, courts were closed. I told her, hey, I'll go down to the 22nd Circuit Court as well and confirm that this is indeed a valid document to prove to her that yes, this is a valid document.
Defense shifts strategy here, away from the defendant's conduct and toward the process. They question how unusual this is, how often troopers serve custody orders, and whether this situation is rare. But rarity doesn't equal invalidity. In fact, the trooper admitting this is his first such case actually strengthens the prosecution. It shows this isn't routine harassment. It's extraordinary because the conduct is extraordinary. The defense is trying to frame this as over-policing a civil matter. Judge Simpson immediately signals he doesn't agree. When a court order is ignored, enforcement isn't optional. It's required. This is a classic courtroom moment where the defense talks around the core issue because they can't talk through it. Insight: when the defense attacks the system instead of the conduct, it's often because the conduct is indefensible. Audience check. Do you think police should stay out of custody disputes or step in when court orders are ignored?
Okay, and did you do that? Did you follow up with the 22nd Circuit Court?
Yes.
Okay, did you get some kind of confirmation about the validity of the document?
Yes, I had spoken to one of the clerks, I believe her name was Miss Thompson, and she confirmed that that document was signed on the 7th by the judge's name is spacing right on my mind here, but
Judge O'Brien?
Judge O'Brien, thank
Thank
you. And she confirmed that that was a valid document.
Okay, and did you then relay that information to Miss Lovely?
Yes, I did.
Okay, so you've now told her about it on the 7th, gave her to the 10th to comply, and then on the 13th, tell her that it's a real court order. What was her response to you in regards to that information?
Once again, she told me she was refusing to return the child, and after a brief few words, she hung up on me.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this witness.
Cross-examination.
This exchange is subtle and dangerous for the defense. Yes, the trooper couldn't immediately see the order in the system, but that doesn't mean the order didn't exist. Court systems lag. Orders take time to post. Judges know this, and so do attorneys. The problem for the defendant is that she didn't independently verify anything either. No clerk call, no emergency motion, no appearance before a judge. Just refusal. Judge Simpson later makes this explicit. Disbelief is not due diligence. If you're subject to an order, the burden is on you to confirm compliance, not on everyone else to convince you. Legal principle: administrative delay does not suspend judicial authority. Viewer question: should courts do more to make orders instantly visible, or is compliance still the responsibility of the parties?
Trooper, in the 4.5 years that you've worked for the state police, is this a common thing, common part of your duties?
I'm sorry, what do you mean? As in,
I guess is
are you
serving orders for child custody, is that a common part of your duties?
in my 4.5 years, this is the first time I've had to do it.
The only time you've ever had to do it is in this case.
Yes.
So it's unusual. And you indicated that you spoke, well, I guess let me circle back. You received the order from Detective Buxton, correct?
Yes.
And where did Detective Buxton get it from?
And he advised me that he received it from Mr. Johnson.
From Mr. Johnston.
Yes.
So Detective Buxton didn't get it directly from the court either,
Unless he actually,
to your knowledge.
to my knowledge.
Okay. So you then told, as you indicated, you met with Ms. Lovely and you told her about the order, and she indicated that she had doubts about its authenticity, correct?
Yes.
And you testified already, but that she told you that a motion had to that effect had been denied, correct?
Yes,
Right. So she asked you to independently verify that that was accurate. And you agreed to do that.
yes,
And you told her that you would do that.
yes,
Okay. And then by the time you were able to do that was September 10th, correct?
to
To
Yeah.
verify the document was authentic.
the 13th, she didn't,
February, excuse me, February, not September.
she requested on the 10th for me to verify the document, not on the 7th.
Okay, so you agreed to do it on the 10th
Correct,
and then you verified it on the 13th.
correct. 10th was Friday night, courts were closed.
Right.
The 13th would have been the earliest, that was Monday morning.
So she had indicated, when did she indicate to you that she was concerned about the veracity of the document?
On the 10th.
She didn't tell you that on the 7th?
I do believe she probably did indicate it on the 7th.
Okay.
I don't recall.
Okay, so things she told you on the 7th, she certainly told you about the CPS investigation on the 7th.
Yes, she did.
Okay. Judge, if I could just have a moment.
You can.
Did you ever attempt to independently verify that that order had been entered prior to February 10th?
No,
You didn't look into Odyssey or any other system?
yes, I did.
You did?
Yes.
Okay, what did you do?
It's not really a system I'm familiar with,
Mhm.
so I attempted to look through, the online court system to see if any of that documentation, or through the family court system,
Mhm.
to see if that order had been, posted within it, and I did not see it in it.
And when did you do that?
I don't recall which date I did that.
Would you agree that it was somewhere between the 7th and the 10th?
Yes.
So you were, between the 7th and the 10th, you looked and you weren't able to see that that order was entered either.
With redirect complete, the evidentiary phase is effectively over, and the writing is on the wall. The prosecution has established notice, refusal, and duration. The defense has established confusion, and confusion alone doesn't negate intent once clarification occurs. From here forward, this becomes a legal argument, not a factual one. Courtroom reality. Once facts solidify, outcomes depend on interpretation, and judges interpret compliance very strictly.
Correct.
Nothing further, Judge. Thank you.
Any redirect?
I just want to reiterate. Did she express some doubt over the veracity of it on 7th of February of the order that you presented to her?
Yes, she didn't think it was a real document.
Okay. And then she might have also expressed some doubt on it on the 10th.
Yes,
That caused you to follow up with the court on the 13th.
yes.
Okay. Thank you. I don't have any.
All right, thanks, Trooper.
Thank you.
Yes, sir. Any additional witnesses?
I don't have any other witnesses, Your Honor.
Any witnesses for the defense?
No, thank you, Your Honor.
All right,
Your Honor, at this point in time, I motion to find the defendant over on the charges contained within the information, the one count.
response.
Your Honor, I object. First of all, it seems to me that based on the testimony, this entirely occurred in South Lyon. So I'm not really sure that there's jurisdiction. This appears to have, the child was in Oakland County the entire time. So I think there may be a question as far as venue. However, on the facts of the case, the testimony is relatively clear from the trooper that he showed her this order on the 7th. She indicated to him that she didn't think it was accurate. They both, I think, he independently attempted to look in Odyssey, couldn't find the order. There was an order, a motion that was made and denied, which was testified to by Mr. Johnston. So at the very least, it makes it clear, I think, that there's confusion over what order would be entered or what order would be accurate if there was, this motion was already denied on one motion and then entered on another. Additionally, Your Honor, when the officer presents this to her and she indicates that she doesn't believe it's accurate, he agrees to look into it. Just a reasonable person would interpret that the officer is considering that possibility and is looking into it. If the officer is looking in to determine whether or not the document is accurate or true, it's reasonable for a person not to follow it until they're told that it is.
Or that they go and determine that themselves.
And she hasn't testified that she attempted to do that yet. However, need to prove that she attempted to do that, and it wouldn't have done any good because the officer already indicated that order was not in the system yet,
Or that he couldn't find.
or that he couldn't find it. But it does take time for those orders to appear. She couldn't independently verify it. By the 10th, that's now her parenting time. She hasn't received verification from the officer yet, who's indicated he's going to look into it. He does. She gets verification on the 13th, but that order does not change, and the court indicated that order does not change her parenting time. Now she's into her week. So the child stays with her until the 17th, and then the child would go back to the child's father on the 17th, according to the parenting time agreement. That's obviously changed by the February 14th order, but that's not really what we appear to be discussing here. The issue seems to be this time period from the 7th to the 10th. Because the order that issued on the 14th said she had until the 24th to return the child, and the child was taken by the father on the 16th. So we never got to the violation of that particular order. So based on all of that, Judge, based on what the officer told her and what the officer did and how it would imply to her the possibility that this order is potentially untrue or invalid, he couldn't independently verify. He couldn't tell her that it was accurate until her parenting time had started. I would ask the court to dismiss the charges in their entirety. If nothing else, perhaps it's the basis of a show cause that could have been handled in family court, but as far as a parental kidnapping, I don't think it rises to the level to criminal conduct when the officer himself agrees to take on the task of verifying the veracity of the document.
I would ask the court, I know the court's probably already aware of this. Anything that our arguments are not evidence, but anything that Mr. Overwater argued was that what she did, there was no testimony to that. So let's just focus on the evidence that we have. Take or retain for more than 24 hours the child with the intent to detain and conceal the child from the child's other parent. What do we have? On the 6th, CPS says that
This rebuttal is devastating because it's chronological. The prosecutor walks the judge through each day, step by step, showing how many opportunities the defendant had to comply. The phrase, "she rolls those dice," says everything. At some point, risk becomes choice, and choice becomes liability. This argument reframes the case from confusion to gambling with court authority, and judges do not tolerate that. Legal takeaway: courts punish calculated risk-taking when it involves custody and court orders.
Mr. Johnson testified, CPS indicates that child custody is to resume as normal. At the 7th, he's supposed to pick the kid up from school. The child does not go to school that day. That prompts Mr. Johnson to then turn his investigation both to the police as well as friend of the court. He did this order. He talks with the trooper. Trooper turns around, talks to mom. At that point in time, mom is on notice. She says, "I'm not returning the child." I don't believe that's real. Fast forward to the 10th. He tells her, "You have 24 hours to do this, or you could be looking at charges." She rolls those dice. She says, "Well, I'm throwing it." The 10th, nothing changes. Custody has not changed. Mr. Johnson testifies he has not received his kid, his child, in those intervening days. Trooper Pitzel goes back on the 10th, says, "Hey, what's the deal with this order?" She says, I don't believe it's real. I'm not giving the kid back." He verifies it on the 13th at her request, verifies that it was in fact real. She says, "I'm still not going to return the child." It is what it is. 24 hours she had to return the child or comply with the custody agreement. That order was entered on the 7th. She was made aware of it on the 7th. There's no testimony to suggest that there was anything else that was going on other than there was this order that she had to comply with, and she didn't comply with it between the 7th and the 10th. So for that, Your Honor, as the court knows, this is an order out of our circuit court that gives this court venue and jurisdiction. That's where the order arises out of. That's where the underlying custody agreement comes out of. This court giving this court jurisdiction over this matter. Therefore, I would ask the court to bind the defendant over on the charges contained in the information.
I think there may be two bases for certainly venue and jurisdiction of this court. The one that's brought up by the prosecutor, so I can dispose of that. It's enforcing a Washtenaw County order. Also that the venue is stated on the complaint is Northfield Township. There's going to be the 1 mile, certainly, or any conduct that occurs within that. So the court does believe it has jurisdiction in it.
Judge Simpson dismantles the jurisdiction argument in seconds. The order originates here. The violation affects here. Venue is proper. This is what judicial confidence looks like. No hesitation, no uncertainty. When judges resolve jurisdiction this cleanly, it's usually because the argument never had legs. Insight: jurisdiction challenges often signal a weak substantive defense.
Venue is proper here. As with respect to the elements of this offense and when it occurred, what a wonderful world we would have if defendants who were presented an order by a peace officer were able to say, I don't believe the order, and just not comply without doing their own checking, without doing their own, I guess, footwork on it. Certainly, officers may assist in that, but once presented with the order, it is the person who is subject to that order's obligation to follow it, check it, verify it, and make sure they're in compliance with it. This defendant didn't do that. She just said, I don't believe this order, and then left it to everybody else. What is also clear from the testimony is that the parental father knows that it's his time and he has that order. He follows all lawful means to obtain the order. The order gets served on the defendant. The defendant says she doesn't believe it. The trooper told her she had 24 hours to comply with the order. She didn't. The question then becomes, well, and that's going to be from the period really from the 8th, because of the 24-hour period, to the 10th, that she did not comply with the order. And that in and of itself constitutes that offense. I think it may be a question of fact for the jury as to what the February 17th order means in terms of it going back, because there are different interpretations. One interpretation of that order, on the face of that order, one interpretation is, if you've interfered with my custody, then I basically take your week. So I still do the off and on, but now the weeks are reversed. That's one way to interpret that order, because it's just week on, week off. The other way to interpret that order is we go back to the normal schedule. I don't know which way that order really reads on the face of it, but in either event, I mean, and that to me says that that's going to be a question of fact.
Is where the judge shows restraint. He openly acknowledges ambiguity in the custody schedule, but explains why it doesn't save the defendant. Even under either interpretation, there's probable cause. That's the key. Judges don't need certainty at this stage, only enough evidence to proceed. This careful reasoning protects the ruling on appeal. Legal insight: probable cause doesn't require perfection, only plausibility.
Because it may very well be that the defendant then interfered with what would become the child's father's week that would have previously been her week, because that week on didn't happen. So that's a reasonable interpretation in this court's mind, certainly, and having seen it before, of these orders. Under either analysis, and again, I'm here to decide whether or not there's probable cause to believe that a crime was committed. not as to whether or not she has complied with the order, nor to necessarily give an interpretation of that order. That's for other proceedings. Given all of that, the court does believe that the defendant has committed the offense of kidnapping, custodial interference, and that people have sustained their burden of showing that by probable cause, either, so that we're clear, either is to that period after being presented with the order and not complying within 24 hours, or in retaining the child if there were a switch of weeks for that following week.
And there it is. The defendant is bound over for trial on custodial interference. This isn't a conviction, but it is a serious escalation. The court has found enough evidence that a crime may have been committed. This moment marks the official transition from family chaos to criminal consequence. Reality check: many defendants believe family court shields them. It doesn't.
Under either one of those analyses, the people have sustained their burden. And therefore, the defendant is bound over to stand trial on this charge.
I'll acknowledge receipt of the information, Your Honor. I'll waive its formal reading, and my client will view this allegation.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea. All right.
As a point of clarification, if I may,
Yes.
the court's recitation on the find over, the court referenced an order of February 17th.
Oh, I meant February 7th.
Okay. Perfect.
If I said 17th, I meant February 7th. All right. Court will indicate the defendant standing mute. Enter a not guilty plea. Pretrial will be set for
October 16th at 1:30 p.m. with Judge Slay.
October 16th, 2023, 1:30 before Slay. Is that
That's a Monday.
that's a Slay Monday.
Your Honor, there is the violation. I don't know
Yes.
if the court wanted to address that.
I do. So that we understand, and I don't how we got here, that the court had ordered Miss Lovely on July 27th that there was to be no posting, commenting on social media regarding this circumstance, or particularly the child, or anything having to do with this. All social media that she had previously posted regarding this case was to be removed, and that the court was very specific that it included anything to do with the child directly or indirectly. That was on July 27th. We returned for a hearing August 17th. The people, I think, filed a motion or a request to an emergency motion on the 9th, I think it was, to revoke her bond. At that time, the court reviewed it. There was a partial hearing on that. Well, there wasn't really a hearing on that date when she came back on the 17th. Based upon what the court saw in the court's previous order, the court did indeed revoke the defendant's bond, remanded her to the Washington County Jail, have subsequently released her from the Washington County Jail, but had set a bond hearing to address the issues in this case, because there was a claim that the subsequent posts were not with reference to the case. And that's where we are.
And I believe that subsequent post was something about a stalker, and then she referenced that, or at least the indication was that was in reference to a landlord or some kind of landlord tenant dispute.
Correct.
That is my understanding as well.
Where was that landlord tenant dispute heard? And what was the name of the landlord?
Her name is Emily Knox. The landlord tenant dispute was at Water Edge Apartments.
Where was the case heard?
There was no landlord tenant case. We just had a eviction case coming from the property management. But there has been, police report filed for different disputes. So previous property manager does not.
So there was no landlord tenant action that was filed?
Not through the courts, there was a police report, police have been called, that's made, and only from like associated with the police. That really had to be from our eviction. We're part of the edge because of the situation with the old property manager. All right, and that's been taken care of.
It's my understanding that there was an actual court case, but, within
That's what I had.
50 seconds.
Excuse me, the eviction case.
Right. That's Water's Edge Apartments versus Justin Hatchett and all occupants. So
Who is Justin Hatchett?
I believe that's her
That's one.
significant other fiance.
We're both on the lease, he just was named first.
So how does this relate to that?
There was an incident,
I'm sorry, Judge. How does what relate to that?
How does the stalker relate to that case? Because I'm a bit confused only because before she had told me there was a landlord tenant case, then she told me today there isn't a court case, but now I find out that there is a court case, and I'm now trying to relate the language that she was using to that case.
Well, my client indicates, judges, that she was being harassed and stalked by the former property manager. What was the name?
Amberly Knott.
Amberly Knott. And that's the person to whom she was referring when she made that post. There is an email addressed to Ms. or it's to purporting to be to Amberly. I don't know if that's been tendered, but.
You know, I find it interesting. There was also this issue with the GoFundMe, right? And so the GoFundMe is the GoFundMe. I recognize it's been disabled. It has not been deleted. But in that language, when she's talking about what had happened, she says, still being harassed, stalked, manipulated, and talked about by my ex-husband. So she's referencing that same language that comes in, what was it? In that post from, I think, July 27th, which that apparently happens to coincide with one of our dates here.
Yes.
So it's just too convenient. And I find it too remote to refer to a stalker or a landlord as a stalking, because, a landlord is a stationary kind of thing. It's the building. So it's just strange, and it seems too remote.
So Judge, the GoFundMe was early July. That was before, I believe, the court's order, is my understanding, when that was created, and it has been disabled. A person can have more than one person harassing them in their lives. So while she may have had, obviously there's a difficult relationship that she has with her ex-husband, that does not mean that she's not also having issues with this landlord property manager. Again, this isn't the owner, this is the person managing the properties who's there in the areas, driving around in a golf cart, is watching her and has been harassing her. That is what she's reporting. I would ask the court, based on the vagueness of what that post was, to dismiss the bond violation. She's already spent, I believe, a week in jail as a result. And I've admonished her to stay off of social media in its entirety during the pendency of this case. And I don't believe there's any indication that there have been any issues since she was released from custody.
Well, let me just say this. I don't think the defendant believes any court's order.
This is not just a warning, it's a forecast. Judge Simpson makes it crystal clear. Continued defiance will be met with harsher consequences. 7 days with credit served isn't leniency. It's mercy paired with notice. Courts don't warn twice. Judicial message? Compliance is no longer optional. It's survival.
It distressed me, first of all, in coming back that there was a violation of my order. Right? Then when I'm listening to testimony here, Judge O'Brien issues an order. She didn't want to follow it. She just doesn't believe that people are going to issue orders that may affect her and that she can just decide to do things as she will. I hope her time in jail has sort of bemused her of that idea, especially when it comes to me. I think she's also going to run into a different type of animal well, I don't mean that in a bad way, but a different type of judge when it comes to Judge Slay. And I would almost just dare her to not follow Judge Slay's order to the letter. Because 7 days probably won't be long enough. What I'm going to do is I'm going to find that there's a violation, sentence the defendant to 7 days credit for the 7 she served. I'm also going to issue a new order, or as part of her order going up. And I think it's wise advice, Mr. Overwater. The defendant is not to be on any social media. No use of social media. Ma'am, do you understand me? Thank you.
Thank you.
Otherwise, her bond will continue at this point.
Thank you, Your Honor.
Thank you, Your Honor.
This case is a textbook example of how belief does not override authority. The court didn't punish confusion, it punished refusal. Repeated refusal, documented refusal, confirmed refusal. Judge Simpson didn't decide who the better parent was. He decided who followed the law and who didn't. The defendant was bound over for custodial interference, warned about social media violations, and placed squarely on notice that future defiance will carry heavier consequences. The broader lesson here is simple but powerful. Court orders are not debates. You don't get to negotiate them. You don't get to ignore them. And you don't get to outsource compliance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe to Shazi Gavel for more jaw-dropping courtroom breakdowns. Justice moves fast, and we break it down faster.